Hello, everyone. This is Regina Sun, and welcome to today's Legal Moment. Today's topic is on the Defense of Marriage Act. The United States government filed a petition with the Supreme Court asking them to review the act to determine whether or not it is constitutional or unconstitutional. The government wants the Supreme Court to particularly look at two sections of the act. Section 2 of the act, which provides that no state is required to give effect to any public act, record, or judicial proceeding of another state that treats a relationship between two persons of the same sex as marriage under its laws. So this pretty much says that if state A recognizes same-sex marriages, state B does not recognize same-sex marriages, state B does not have to recognize a marriage license given in state A. Section 3 of the Act, which is another provision that the government wants the Supreme Court to look at, defines marriage and spouse under federal law to exclude marriages between persons of the same sex. Therefore, the definition of marriage under federal law is between one man and one woman. And this is significant because there are a lot of benefits that marriage couples receive by virtue of being married. And some of these benefits are federal benefits. So if federal law is not recognizing same-sex marriage, then same-sex couples cannot receive federal benefits. So there are a lot of courts that have already looked at this issue, and that's one of the things that the Supreme Court determines if whether or not there's some kind of conflict among appellate courts as to various provisions of law. And what the government is arguing is a lot of courts have already decided that this statute, the Defense of Marriage Act, is unconstitutional. Now, it's looking at the Fifth Amendment, and the Fifth Amendment of the Constitution requires equal protection or due process under this amendment. So all persons who are similarly situated should be treated the same. So the government is already saying to the Supreme Court, look, this is a historically disadvantaged group. Homosexuals are being treated differently under this act, and therefore this act should be held unconstitutional. Now, what the court is going to look at to determine whether or not an act is unconstitutional is not only whether it elicits the Constitution, in this case the Fifth Amendment, but also if there is an important government interest and if the act that the government has put in place is narrowly tailored to meet that interest. So in this case, some of the courts have decided that yes, this government is saying there's an interest in some type of moral approval or child rearing or promoting heterosexual marriage, but this statute is not narrowly tailored to meet those interests. For one, there are a lot of states that permit same-sex couples to raise kids, and this statute is not hindering that. And there are also states that are permitting same-sex couples to marry and receive benefits. So this statute is not hindering that. Therefore, there's no type of connection between the Defense of Marriage Act and these important interests that the government is claiming to try to meet. So I want to know what you guys think. Do you think the Defense of Marriage Act should be held unconstitutional, or do you think that it should remain in place and be held constitutional? Tweet me at Regina Sun ESQ, and I look forward to hearing what you think. Thanks for listening, and that is today's Legal Moment.